Hi, good afternoon, everyone. I'm Charlie Wen, Associate Professor and a member of UNSW Law's Herbert Smith Three Hills CIBEL Center, and I'm delighted to welcome you to the Young Scholar workshop on corporate and competition law. I would like to begin by acknowledging the Badigal people who are the traditional custodians of the land where UNSW Law stands. I would also like to pay my respects to the elders, both past, present, and emerging, and extend that respect to other Aboriginal and Torres Strait Islanders who are present today. As you know, we are facing the most significant public health challenge in the 21st century. COVID-19 has caused hundreds of thousands of life loss and in fact more than 5 million people globally. The pandemic's economic impact is unprecedented, and we are facing the shadow of global economy recession. Corporate law has a function to lower the operational cost and increase firm efficiency, while competition law may protect the consumers and small businesses. Further, both corporate and competition laws externalities can directly and indirectly accelerate the economy recovery and help fight back the pandemic. I'm glad to announce that we have 5 promising corporate and competition law young scholars on the panel. Young is very important. Each of them is bringing an exciting topic for us. The first speaker is Ms. Chi Guo Bell. Bell is a PhD candidate in the Faculty of Law at the University of New South Wales. Bell holds LLB and LLM from Northwestern University of Political Science and Law. She currently research focuses on Chinese cross-border listed companies' continuous disclosure in Australia. She has presented a paper at Corporate Law Teachers Association Conference, Cross-Strait Civil and Commercial Law Postgraduate Exchange Forum, and co-authored the paper at Company and Financial Legal System International Conference and Chinese Business. Today, she is going to discuss some thoughts on new voluntary disclosure in China. And the second speaker is Dr. Rosa Nogozayeva. She serves as a Vice President General Counsel at Nazarbayev University, Kazakhstan. Until August 2020, she held the position of the postdoctoral fellow at the Center for Asian Legal Studies at NUS, National University of Singapore. Before joining academia, she also practiced the law for more than 7 years as an in-house commercial bank counsel. She holds a doctorate degree from Cornell Law School. Her research interest includes comparative corporate law, corporate governance, state-owned enterprises, law and development, law and public policy. She will bring us a topic, very interesting topic, on how COVID-19 is changing the landscape of corporate governance and the implications of the change. And the third speaker is from UNSW, Shor Yang. Shor is a PhD candidate at UNSW Law and a student member of Herbert Smith Three Hills China International Business Economic Law Center. She holds 2 masters from the Queen Mary University, UK, and the Shandong University, China. Her primary research area is civil and commercial law, with a particular focus on nonprofit organization governance. Of course, her topic is on a very heated topic. How to make Chinese nursing home more accountable under the current academic particular situation. This is timely, especially considering what we have seen in the nursing homes around the world recently, especially some people also suggesting at the moment we should close all nursing homes. The fourth speaker is a competition lawyer, Dr. Sinchit Lai, also known as Martin. Martin is a recent SJD graduate from University of Pennsylvania Law School. Great to see an alumnus here. Martin's research interests are competition law and law and economics. He has written and published scholarly works about antitrust law. A few of his publications have been nominated for the Concurrence Antitrust Writing Award. In addition, Martin has worked as a research assistant at the Center for Technology, Innovation, and Competition, and at the Wharton School. Martin is a member of the New York State Bar. He's going to discuss some key issues on Hong Kong competition law. The last speaker is also a competition slash IP lawyer, Peyton Wu, also known as Matthew. Matthew is a joint PhD candidate at Kwok Won Law School, Shanghai Jiao Tong University, and a faculty of law at University of New South Wales. Matthew worked as a legal intern at the Intellectual Property Tribunal of the Supreme Court of PRC in 2018, also a legal assistant of the then State Administration for Industry and Commerce, which is Chinese competition agency, in 2017. He was a visiting fellow at Chicago Kent College of Law, faculty of law at University of Warsaw. Matthew's primary research area are competition law, trade secret law, and intellectual property law. Matthew is bringing us a fantastic and hot topic relevant to U.S.-China trade war and the protection of trade secrets in China. So every presenter will have 10 minutes to develop his or her topic, and later Deb and myself will provide some commentary for around 8 minutes each. So let's welcome our first speaker, Belle. Her topic is an analysis of impact of the new voluntary disclosure on the continuous disclosure in China, foolproof or full of loopholes. Belle, please.
Thanks for CIBEL accepting my paper to be presented in this workshop, and thank you all for virtually coming to this session. The topic of my presentation is an analysis of the impact of the new voluntary disclosure on continuous disclosure in China. Information asymmetry in the securities market puts investors in a weak position when compared with listed companies. Ensuring the quantity and quality of information floating in the securities market has three advantages in that it enhances the protection of vulnerable investors, maintains the integrity of the securities market, and plays a vital role in the corporate governance. In China, a relatively well-shaped corporate disclosure regime comprising mandatory periodic and continuous disclosures is already in place in achieving the necessary transparency goals in the securities market. The core legislation in this area, namely the Securities Law of the People's Republic of China, has undergone several major revisions and minor amendments over time, each having been undertaken with the aim of constantly refining corporate disclosure regimes and enhancing investor status. Despite several years of work, the corporate disclosure system continues to suffer from several deficiencies, particularly in guaranteeing the availability of adequate information for investors. The materiality standard and the continuous disclosure mechanism serves as an important threshold to define the appropriate scope of information that is significant enough to affect the securities market and thus need to be disclosed on a timely basis. Although legislators have always aimed at enhancing investor protection and the continuous disclosure mechanism while revising and amending the law, substantive amendments to the materiality criteria have been rare. The materiality standard for continuous disclosure in China has been a price-sensitive one since their inception. That is, matters that may have impacts on share prices are considered as satisfying the criteria of information materiality. However, scholarship in China continues to engage in an ongoing debate on the incompleteness of the price-sensitive standard. In judging materiality and the reasonableness of incorporating investor decision standards into the securities law, especially pertaining to investor protection. This can be understood through the efficient market hypothesis, which suggests that when the price of securities fully reflects all available information, the securities market is supposed to be efficient, and accordingly, the price of securities at any time will represent the real or fair value of those securities. However, how effective and opportunely share prices can reflect the information depends on the different levels of efficiency of certain securities markets. If the market is a strong or semi-strong one, investor decision and stock market prices will have positive correlations on a timely basis. and the final outcome of the judging the materiality of information utilizing either standard will not produce any differences. In reality, however, the Chinese securities market is still a weak form efficient market, with the price responding to information in a strongly lagging mode. Owing to the lack of materiality and the price-sensitive test, it may not be mandatory to disclose information that may have a material impact on investors. In response, the most recently revised version of the securities law in China, the Securities Law 2019, framed an investor decision standard for the first time. It's not directly introduced into the mandatory continued disclosure provisions. Instead, the new securities law considers disclosing information that is investor decision sensitive as a voluntary obligation, irrespective of whether such investor decision standard information is demanded in the mandatory or voluntary modes. Provision still represents the Chinese securities legal system's recognition and admission of the investor decision standards, and that the securities law starts to focus on factors closely related to investors. As a matter of theory, if listed companies have enough incentive to make voluntary disclosures according to this newly added provision, the revision would bring the capacity of the investor decision standard in investor protection into reality, and be potential to make up blind spots left by their price-sensitive standards. It's quite paramount to reiterate that the requirements on disclosing investor decision-sensitive information is only voluntary duty for listed companies. It's a company that gets to decide whether to disclose such information or not. Mandatory regulations only govern situations wherein the investor decision-sensitive information conflicts with the information required under mandatory rules, or where such information has a tendency to mislead investors. To this end, if we reassess the newly added voluntary disclosure in the context of existing continued disclosure performance and enforcement in China, is this really an advancement without any loopholes? According to our analysis of 1,077 civil remedy cases related to continued disclosure from 2012 to 2019, up to 257 cases have ever considered the effects of the disputed information on investor decision-making in the aspects of no matter the share values or investments. It cannot be denied that the investor decision standard for material information within the continued disclosure requirements for listed companies has already been adopted in judicial practice according to the judge's discretion. Both judges and listed companies consider factors pertaining to investor decision-making. They differ in their perceptions. To be more particular, judges usually employ the price-sensitive standards and the investor decision standard on a step-by-step basis to help expand the scope of material information with potential effects on the securities market as reasonably as possible. Nevertheless, listed companies usually rely on the non-satisfaction of investor decision standards as the ground of opposition to escape continued disclosure duties. However, the new voluntary disclosure provision clearly distinguishes between the price-sensitive and the investor decision standards, and only adds voluntary obligations on the latter. Thus, it may be inferred that only information that satisfies the price-sensitive standard is necessary under the mandatory continued disclosure provisions. Listed companies are more likely to escape their continued disclosure obligations by pointing out the lack of fulfillment of the investor decision standard as the grounds of opposition. It cannot be denied that the new voluntary disclosure is still full of loopholes, despite its positive reform philosophy and expectations, and it's hoped that the next step in this area will highlight alternative means of closing such loopholes. In the short term, the Supreme People's Court of the PRC is able to enact the corresponding judicial interpretations to clarify and improve the certainty of the materiality standards and disclosure requirements, while taking advantage of just issued new securities law. In the long term, it would be better to incorporate investor decision criteria into the general principles on mandatory continuous disclosure rules. That's all. Thank you.
Thanks very much, Belle. Then the next one is Rosa. Rosa's topic is corporate law after COVID-19. Rosa, please.
Thank you very much, Professor, for your kind introduction. Thanks, CIBEL, for hosting this workshop and for the opportunity. In my presentation, I'm going to talk about corporate governance-related issues arising from the response to the COVID-19 outbreak and touches upon potential changes this outbreak can bring or reinforce. While recent legislative and regulatory changes are perceived as temporary arrangements, the impact of the crisis on corporate stakeholders and governance practices is significant and urges to a comprehensive legal and policy response. The pandemic can trigger a fundamental shift in the manner companies are governed. The corporate governance literature can be generally divided into three main groups of theoretical discussions. The first set of theories analyzes the term from the prism of shareholder supremacy and agency costs. This approach to corporate governance is grounded in transaction costs and agency theories and treats the firm as a corporate contract. Viewing the firm as a nexus of contracts, this theory focuses primarily on the equity interest as the only residual claim which bears most of the costs and risks of corporate decisions. The maximization of shareholder value becomes essential to corporate performance then. The second line of argumentation focuses on market competition as a critical corporate governance tool. From this perspective, corporate governance can be defined as a set of mechanisms that transform market signals into corporate decisions. The market approach analyzes corporate governance in the context of the market, wherein different factors and predominantly market competition pushes the firm towards efficiency. But the problem arises if no capital, labor, or product market exists, or those markets are significantly disrupted, or disciplined managers and provide sufficient capital. In this case, market signals cannot be adequately translated into corporate decisions. Finally, the third concept focuses on a public good hypothesis, which suggests that companies are meant to contribute to the public welfare. However, corporate governance approaches do not exist in a vacuum. They interconnect with the entire institutional ecosystem in a country, existing in a country, and go beyond companies themselves. In many countries today, their legal institutions and social security systems continue evolving by responding to existing problems and demands. I hope it's not that disturbing for those who listen. In many countries today, their legal institutions and social security system, as I mentioned before, is still evolving by responding to economic development issues, health care issues, and market sustainability. These mandates was critical even before, had been critical even before the global pandemic, but now seeking to solve these socio-economic agendas. While urging structural reforms and mitigating the exposure to the COVID-19 crisis, governments attempt to find optimal legal norms and policy actions. However, the pace and impact of legal responses to the pandemic also vary across different countries, with some similarities I will highlight next. As the COVID-19 pandemic goes on, most governments opt to focus on the protection of business by reducing the regulatory burden on companies severely affected by the pandemic. Among other anti-crisis measures, we can highlight the following main categories. They relate to corporate meetings, access to corporate documents, extension or renewal of the terms of the board members, modification of certain filing procedures, and the extension of formal submission deadlines, as well as dividends and share issuance. The measure I just mentioned represents an immediate response to the new environment caused by the global pandemic. Certain norms, being very technical, will certainly remain because they are short-term. For instance, the extension of report periods. Other norms might symbolize an important transformation of corporate law and governance in the future. First, the expansion of digital space and its implication for many aspects of corporate governance will continue beyond the COVID-19 crisis and evolve to become a conventional norm. Increasing penetration of technologies in corporate decision-making and management calls for closer examination of the existing corporate governance standards to understand if the standards still are relevant and provide necessary protection, or they require modernization. While the effect of frontier technologies on corporate governance can help with the transparency, simplification, and probably speed for many business processes, it also involves new challenges and reinforced technology-related risks. The unequal spread of technologies and financial resources across regions, countries, and cities determines an enabling environment for companies to access and apply new technological means in their daily operations. This uneven distribution affects the successful utilization of virtual space in corporate governance. Digital technologies and the internet, as we all know, trigger the issues of privacy, data collection, and cybersecurity. These issues call for an effective institutional framework and regulation that allow maintaining an efficient level of access and disclosure on the one hand, and ensure that corporate directors and executives act fairly and responsibly in the interest of the company on the other hand. Second, the global pandemic calls for revisiting the standard allocation of powers in the firm. As a result of current restrictions, the role of shareholders can become even more powerful in many jurisdictions, which are characterized by ownership concentration. In this scenario, the board becomes less strategic and more instrumental. And this scenario also may prompt the transition from the orthodox understanding of shareholders as investors and residual claimants to the more robust sense of shareholders as owners of the firm. Another possible scenario applies to public companies with numerous dispersed shareholders. Here, the pandemic may increase the monitoring and information gap between directors and managers. The pandemic also increases the pressure on corporate directors to find new solutions for the close oversight of executives to avoid potential liability. Navigation through current unique circumstances might call for another review of directors' traditional duties. The standard duties expect directors to deal with the effect of the COVID-19 pandemic with the same level of business judgment and excellence that they would have if they were acting in the pre-pandemic world. However, the socio-economic environment created by the global pandemic may set up new priorities and needs for companies to follow and new investment strategies to adhere to. At the time of global threat, many resources are limited and risks are high. That's why decisions that are appropriate, acceptable, or fair go beyond shareholder preferences and shall be defined from broader policy and social welfare perspectives. This means that the discussion around corporate purpose will re-emerge and reinforce as well. Finally, the pandemic can further strengthen the role of the state and expand the influence of state-owned enterprises. The pandemic currently raises the demand for state funds among private companies, and the adequacy of capital resources will expand the influence of the state as well and provide more channels for state interference. That's why academics and policymakers talk about the new role of the state or emergence of the stronger state. To conclude, the choice of an applicable legal framework depends on the socio-economic, market, and institutional context of an individual country, or even the allocation of powers and ownership in an individual company. Countries will continue to adopt alternative conceptual narratives that help their corporate law to evolve into systems designed for their own purposes. The influence of autocratic state-driven system will continue to rise. Going forward, additional empirical studies are needed to assess the impact of the global pandemic, and we have to analyze possible negative consequences of the crisis. Since disasters and threats affect countries in a different way, I believe that we need further academic discussion on future corporate governance after COVID-19. Thank you very much, Charlie, and I come back to you.
Thank you very much, Rosa. Very interesting. So the third topic is from Shuo Yang. Her topic is reflecting the accountability system of nonprofit residential care institutions during the COVID-19 outbreak pandemic in China. So Shuo, please.
Okay, Okay, so good morning, everyone. Currently, we are meeting under challenging circumstances. Over the past few months, COVID-19 has become a worldwide pandemic and has caused many changes in both our professional and personal lives. For the aged people, the aged residents living in the nursing homes, they are at a great risk of infection. In many countries, many deaths from the COVID-19 are related to the pandemic in nursing homes. Since the aged residents live in the intensive support, they are more likely to be infected with a chronic disease, and as a result of insufficient protection and isolation measures, a large number of the aged residents has been infected with the virus without access to a timely, effective treatment. Thus, the corporate governance in nursing homes, especially the measures to hold the governing body accountable in nursing homes, has become a hot topic in recent discussions in corporate governance. In China, as most nursing homes are registered as non-profit organizations, accountability of these non-profit nursing homes appears to emphasize the external accountability with a distinct lack of focus on the internal accountability. Government regulators remain the main body of external accountability. Thus, this external accountability system, relying mainly on administrative power, can achieve results in the short term. For example, at the beginning of the Chinese COVID-19 pandemic, since a strong government intervention prevented the epidemic from initially spreading in different cities and institutions. However, the lack of the comprehensive accountability system may pose risks to the long-term governance of the non-profit nursing homes during and after the pandemic. For instance, when the government is unable to supervise the increasing number of the infected residents in non-profit nursing homes, the interest of the stakeholders, especially the interest of the aged residents, are at the serious risk. In my research, I reviewed the accountability literature and defined the accountability in nursing homes as the means through which individuals and organizations are held externally to account for their actions to stakeholders, and as how they take internal responsibility for continuous shaping and screening the organization mission, goals, and performance. Based on that, I analyzed the stakeholder approach taken by the Chinese nonprofit nursing homes. The regulators, clients, and the donors are the key stakeholders in nonprofit nursing homes in their governance. After that, I analyzed the two main problems of accountability. First, for the internal accountability, the board of supervisors is not independent of the board of directors, which prevents it from performing its monitoring function of an adequate standard. More specifically, there is an overlap between the members of the two boards, and the supervisor's remuneration are decided by the board of directors. This issue that raised several concerns because the supervisory board members potentially become actively involved in matters of decision management with the board of directors, and the financial dependence may also conflict with their ability to carry out monitoring from the objective perspective. Secondly, for the external accountability, the enforcement of the governing body relies solely on the regulator, lacking the participation of the other stakeholders, especially the clients of the nonprofit nursing homes are essentially the stakeholders, but they cannot hold the board of directors accountable and get remedies directly when they infecting with the virus. Then, this research has made some suggestions to the legislators and regulators to solve the accountability issue in nonprofit nursing homes. To improve the monitoring function of the supervisory board, the legislator should prohibit any overlap between the two-tier boards in Chinese nonprofit nursing homes, and multiple stakeholders in nonprofit nursing homes should participate in deciding the financial issue of the two boards. As for the enforcement of the nonprofit nursing homes, it's necessary to strengthen the rights of the stakeholders, especially the rights of clients. By this means, the corporate governance of the nonprofit nursing homes will be improved, and we can better protect the interest of the aged people. That's all my presentation. Thank you.
Thanks very much, Sure. Yeah, very interesting. I have a couple questions in later case perhaps I can ask. The fourth topic is from our competition lawyer, Matt Martin. Martin's topic is deterrence of the free track settlement system under Hong Kong's competition ordinance. Martin, please.
Okay. Thank you, Professor Wang, for the introductions, and thank you, CIBEL, for the opportunity. So I'm glad to share with you all my current research about the settlement system under Hong Kong's competition law. So first of all, let me give you some background of my project. So Hong Kong's competition law came into full effect in 2015. Since then, the competition authority, that is the Hong Kong Competition Commission, has brought a number of cases to the competition tribunal. Then in late 2019, the then chairperson of the commission, Ms. Anna Wu, announced that the commission will consider making use of the free track settlement system instead of bringing cases to the court. So the free track settlement system includes first, the commitment system, second, the warning notice system, and third, the infringement notice system. So these settlement procedures had never been utilized by the time the announcement was made in 2019. Then, a few months after the announcement was made, the Commission issued its first infringement notice in an IT cartel conduct case, and for the first time, the Commission accepted a commitment in an online travel agent case. Therefore, it is reasonable to expect more settlements in Hong Kong in the future. In light of this, I started this research project to review the free track settlement system in Hong Kong and to study the impact to Hong Kong if the Commission further utilized the settlement procedures. Because of time constraint, today I will only talk about the infringement notice system. So according to the Hong Kong's competition law, upon investigation, if the Commission has reasonable cause to believe that a party has engaged in an agreement which involves serious anti-competitive conduct, or the party abused its monopoly power, then the Commission may issue an infringement notice to the party. So in the notice, the Commission will set forth requirements for the recipient to comply. And these requirements may include, but are not limited to, taking specified actions, refraining from specified conduct, or admitting to illegal conduct. So the notice recipient is not obligated to commit, but if the recipient commits, then the Commission cannot bring proceedings in the tribunal against the party. As a result, the tribunal cannot hear the case and will not impose a fine on the settling party. So Hong Kong's infringement notice system is very lenient. It is possible for the settling party to walk away with no financial punishment, because as I have just mentioned, settling parties are not subject to fine. Also, it is not mandatory for settling party to admit to their guilt. So whether there's admission of guilt matters, because Hong Kong competition law only provides a follow-on right of actions. That means victims only has a private right of actions after the tribunal has found a violation of the law or the wrongdoer has admitted its guilt in a commitment. So to settling party, this means that they may only face private actions if the commitment terms include admission of guilt. Otherwise, they will face no threat of damages. So is Hong Kong infringement notice system very lenient? Another way to answer this question is to contrast it with a comparable system in other jurisdictions. Take the EU as an example. A comparable system therein is the settlement system. So under this EU system, settling party is subject to both fine and damages. On the one hand, settling parties in EU only enjoys a reduction of fine of 10% instead of a full immunity of fine. On the other hand, it is always required for settling parties to admit to their guilt. Also, EU victims has a full right of actions before national courts of the EU member states. Therefore, settling parties in EU always face the threat of fine and damages. So the comparison between Hong Kong and EU shows that Hong Kong system is more lenient. And here you may ask, why is Hong Kong system so lenient? So in fact, the Hong Kong government who drafted the law did not intend for a lenient system. So in 2010, the Hong Kong government submitted the competition bill to the legislative body in Hong Kong. The bill empowered the Commission to require notice recipient to make a payment up to 10 million Hong Kong dollar to the government. However, during the deliberation process, some legislators and small and medium-sized companies, they opposed giving the Commission any power to fine settling parties. And for example, some of them argue that the amount would be unreasonably high to SMEs, but at the same time too low to act as a deterrent to large companies. So eventually, to address SME concerns, the Hong Kong government revised the bill and removed the provision that empowered the Commission to require a payment. So as a result, Hong Kong's infringement notice system is lenient. In my opinion, it is not ideal to provide settling parties the possibility of no financial punishment, especially when infringement notice system is already considered as the strictest one among the free track settlement system in Hong Kong. Note that no matter in which jurisdiction, Hong Kong or the EU, when the antitrust authority increase its use of the settlement system, it will save its time in handling the case in hand, but at the same time, it will reduce the expected cost of violating the law and causing more violation. And the reduction in expected cost will be higher in Hong Kong than EU because the Hong Kong system is more lenient. This means that the cost of increasing the use of settlement system is more likely to outweigh its benefit in Hong Kong. So how can we improve Hong Kong's infringement notice system? Taking the lessons from EU, I would like to offer two suggestions to Hong Kong lawmakers. The first change is to allow the Commission to require notice recipient to make a payment. So currently, if a party does not settle with the Commission, it may be fined by the Competition Tribunal, and the tribunal can impose a fine up to 10% of the party's annual turnover. Okay, so my proposal is to allow the Commission to require the notice recipient to make a payment at a lower percentage, let's say 5% or 3% of the party's annual turnover. Because the percentage is lower than the tribunal's 10%, so suspected parties still have an incentive to settle with the Commission. But comparing to the 10 million payment cap proposed by the government in the bill before, my proposal would be could ease SME concerns, because now the potential payment is more proportional to the company's size. And my second proposal is to make it mandatory for settling parties to admit to the guilt. So doing so could give victims a right to sue and allow victims to recover damages. Also, this helps to increase the deterrence level of the infringement notice system. So as you can see, my two proposals require the amendment of the law, and the opportunity to revise or to amend the law may not present in the near future. Therefore, in my paper, I also give notice to the Commission on how to minimize the low deterrence problem while increasing the use of the infringement notice system. But I will put you all in suspense for now, and please stay tuned to the paper. And thank you, Professor Wang.
Thanks very much, Xin-Chi. It's a very interesting presentation. Then the next presentation is also from a competition lawyer, Matthew. Matthew's topic is the implications of the US-China trade agreement on the civil protection of trade secrets in China. Is it a game changer? So Matthew, please.
Yeah, thanks, Charlie, and the Civil Center for having me in this workshop. I'm Matthew. Today, I would like to talk about a topic related to the United States-China trade war. As you may all be aware, the US Trump administration began a trade war with China since 2018. The United States and China, the largest and second largest economy in the world, achieved a 3-1 trade agreement early this year. In this trade agreement, one of the top issues is about trade secret protection. Although it can be seen these days, there are even more tensions between these two countries during the COVID-19 pandemic and before the United States presidential election. My research is going to examine what effects the Phase 1 trade deal, which has been enacted, would have on Chinese legal practices. Well, firstly, let's begin with how China protects trade secrets before the trade war. The modern trade secrets protection system was introduced to China in the early 1990s when China endeavored to join the WTO and meet the requirement of the TRIPS agreement. Around the world, there are two basic justifications for trade secret protection, which are intellectual property protection and unfair competition protection. The United States favors the intellectual property protection, while most European countries, such as Germany, take an unfair competition approach. China traditionally follows the European approach. In China's anti-unfair competition law, a trade secret is defined as information that is unknown to the public, can bring economic benefits to the owner, and has commercial value. It is worth noting that, following the German tradition, the condition of applying China's anti-unfair competition law is that the parties should have a competitive relationship. Well, therefore, under China's anti-unfair competition law, a trade secret holder can only file a litigation against his or her competitors who misappropriate the trade secrets. However, it is in practice the employees who usually get access to the company's trade secrets and misappropriate them. It would be very difficult to identify the employees as competitors of the companies. Chinese laws prohibit misappropriations of trade secrets, and the plaintiff should prove the existence of a trade secret. The defendant has identical information to the trade secret, and the defendant illegally achieved the secret. The plaintiff can also achieve civil remedies such as damages and injunctions during a lawsuit. Then we can further discuss how this United States-China agreement stipulates on trade secret protection. Well, I need to mention that although it is a bilateral agreement between the two countries, when it comes to the trade secret protection, the United States has provided a highest standard protection probably around the world. Therefore, if we look into the agreement, all provisions concerning trade secret protection are related to how China should better protect the trade secrets as the current United States measures. The scope of protection in this agreement is trade secrets and confidential business information. Well, through doctrinal analysis of the agreement, we would find that the so-called trade secrets and confidential business information is just the same as what we call trade secrets under Chinese laws. The agreement requires China to include all nature persons and legal persons in trade secret lawsuits. In a sense, it requires China to abandon the requirement of a competitive relationship as we discussed. Well, this is in compliance with the current United States perspective that a trade secret is a kind of intellectual property, which means anyone who misappropriates trade secrets should be liable, no matter the parties are competitors or not. Another highlight of this trade agreement is the burden shifting provision. Some may argue that it was difficult for a plaintiff to prove and prevail in a trade secret lawsuit in China. According to this provision, under certain circumstances, the burden of proof which was supposed to be taken by the plaintiff will switch to the defendant. Now it's time to focus on what effects the agreement will have on Chinese domestic laws. During the process of trade negotiations, China has made efforts to meet its commitments regarding trade secret protection, including amending the anti-unfair competition law and enact judicial interpretations. For example, China abandons a traditional technical and business secret dichotomy and includes all kinds of information of the definition of a trade secret. It also calls off the requirement of competitive relationships in a trade secret lawsuit and provides burden shifting provisions as the agreement sets out. China's Supreme Court also enacted interpretations to allow the plaintiff to acquire injunctions more easily. The influences are more than this. It can be seen that all these changes favors the trade secret holder. But the United States has, through this agreement, succeed in transplanting its high standard legal system of trade secret protection to China. Well, what's more, a trade secret has been a type of intellectual property in China after the trade war. This was also recognized by the latest Chinese civil code this year. I believe that China should enact a standalone trade secret law, separated from the anti-unfair competition law. It is not only because jurisdictions like the United States and EU have all had their own trade secret law, but because of two reasons. The trade secret provision is not consistent with the unfair competition work in China now. For example, other unfair practices in the law still needs the requirement of competitive relationship. The standalone trade secret law can include more than trade secret protection, but how to actively use a trade secret legally. For example, how to license or transfer a trade secret, and include anti-competitive concerns from the abuse of trade secrets. But overall, I believe that the trade agreement is a game changer in China's trade secret protection, and in response to this, China needs to enact a standalone trade secret law. Well, that's all my presentation. Thank you.
Thanks, Matthew. Very interesting. And you also save us a couple of minutes. Okay, so now let's enter into the commentary part of the session. Professor Deborah Healy will be offering commentary on some of the presentations first. Deb is a director at Herbert Smith Freehills China International Business and Economic Law Center. Her research and teaching focus on competition law and policy in Australia, China, Hong Kong STR, and the ASEAN nations. And she has written widely in them over a long period of time. She's a regular visitor to those jurisdictions to teach and research. Within the area of competition law, she is particularly interested in government role in the market, both in Australia and internationally, merger regulation, competition in banking and finance, and the digital economy. Deborah has undertaken substantial research in the development of the anti-monopoly law of China against the background of its political economy, and has written widely along with Chinese co-authors and in material translated into Chinese. She has consulted with and completed the research projects for UNCTAD, OECD, and ASEAN. She is a non-government advisor to the International Competition Network and a member of the Law Council of Australia Competition Law Committee. So, Deb, please.
Thank you, Charlie, and I'm sorry that you all had to hear that very long CV. Look, I commend all of the participants this morning. You all spoke very well and put your ideas across in a very cohesive way. So that's my first comment on the papers as a whole. I will make some very brief comments on the corporate papers because I do teach business associations, corporate law, but some of the areas are not ones which I've explored in depth, and I will leave that to our chairman, who is an expert in that area, but I will make more detailed comments on the competition law papers. So at the outset, in relation to the paper of Bell, I would say that I thought it was extremely well written and very well developed ideas included in it. I would counsel you, however, there are some usages in there which, if you're publishing in English, the meaning is very well understood, but it would not normally be put in an academic paper. So you refer to the system as rough and shabby, and it certainly appears to me to be rough and shabby, but I don't think we would actually say that. But because continuous disclosure is not my area, I don't have very many other comments for you on that, except to say I thought it was a very good paper and very well presented. Rose's paper on corporate governance and the law after COVID. Corporate governance is something that I'm interested in. I'm a director of not-for-profits in Australia, and I can tell you that the experience in dealing with those governance issues after COVID has been incredibly stressful. Things change almost daily. We have not shareholders, but we have members and stakeholders. And it seems to me that we never give them enough information. They're always complaining, and no criticism of that. But I think it's just as hard for them as it is for people who are governing them. And I really liked your comments on future corporate governance after COVID. I think you took a realistic approach to problems arising from it and going forward. And I commend you on your paper as well. The accountability of non-profit residential care institutions by Shro. Clearly, you're right at the pointy end of COVID experience in governance. You looked at the long-term implications for governance, and you raised several really substantial issues of conflict in current governance models, which I think were in existence before but have been really heightened by COVID-19. And as you've seen probably from the press, we have very similar problems in Australia. I think it's a very difficult area, but I thought your paper was very cohesive and I enjoyed reading it. So thank you. To get on to Martin's paper, Deterrence of the three-tax settlement system. Martin, I thought that from an Australian point of view and a Western point of view, the name is a little confusing to me because settlement usually means a legal process to settle outside the court system. And I don't know that the system is exactly what I would have envisaged. I thought your paper was good. It really means, sorry, going back to that last point, it really means that a legal process, not just that the enforcement process is finalised. So I would have thought that a three-track enforcement system may be something which, if you're writing for a more general audience other than just Hong Kong, may be more understandable. I'm also, I think that you, in some parts, you have the paper conveys the impression that any commitment offered to the regulator should be accepted. But I think more subtlety is needed when you're discussing the processes for commitment. It's only if the commitment is sufficient to satisfy the regulator will it be accepted and will proceedings be stopped. So I think you need to, it's not just any settlement that's been accepted. And as someone who used to be a competition lawyer in Australia, our regulator took a very, very tough approach to extracting appropriate commitments from people who were threatened with prosecution before it would accept them. So I think you need to think about subtly rewording some of those provisions. It is a very complex system. I think Hong Kong has the most complex system almost of any country that I have examined. And I think it's really, you need to be a little more upfront about the three-tax system is really a result of lobbying by both small and big business against the imposition of any competition law. I read all of the draft papers and submissions made to them about whether Hong Kong should have a competition law and what it should look like. And submission after submission said Hong Kong doesn't need a competition law. We are the freest economy in the world, which was nonsense, because despite the fact that it's very free in terms of internationally traded goods, there are very many cartels existing both at small and large in relation to small and large competitors. And the concessions made, in my view, to small businesses fairly, you talked about what was proposed in 2010 and how it was changed. Unfortunately, the timing was bad. There were several cases taken by the Singapore Competition Authority against small businesses successfully at around that time, and both big business and small business used them as a way to further water down the proposed law. And I think that the proposed law is a bit, the law which was enacted is a bit of a disappointment, makes life very difficult for the Commission, and people get too many chances. So I would say that. I think in relation to your admission of guilt point, it's interesting, in Australia, just to show you a comparison, we traditionally had to admit guilt before we would, the Commission would accept a settlement, but they seem to have oscillated, and I don't know that we now have to accept, we have to admit guilt. So it just depends. I think admission of guilt is really good and very important, but people are far less likely to want to do that if there's the third party follow-on action. And I think that there's, throughout the world, the existence of the third party follow-on action has created all sorts of complications. There are a lot less cartel actions happening in the US now because of the third party follow-ons. It's making life very complicated. I suppose when you're looking at deterrence, you haven't really covered the deterrence point fully yet, and I know your paper is incomplete, but you will need to discuss what deterrence is and what you think would be deterring to possible offenders. And there's a huge amount of literature on that you might want to look at. But very interesting topic, and thank you for that. And finally, I would like to talk to Matthew and say, Matthew, I found your paper interesting. I've read other parts of your work, but this is a slightly different spin on it all. I guess I would ask you two questions. The first is, in relation to the requirement currently of competitors, do you think that a change to giving it a broader application will actually improve protection of trade secrets in China, or will it be a problem? And secondly, I've got three questions. Secondly, how likely is it that there will be a standalone trade secret law? And what do you think the time frame for that might be? And finally, you mentioned that there should be abuse provisions in the new law, but how would you have that interact with the anti-monopoly law? So those are my three questions. And once again, I'd just like to say thank you very much. And I thought the papers were a high standard and were very interesting topics. So I'll hand back to Charlie.
Thanks very much, Deb. So I think it's my turn to offer some commentary for our great presentations. My research area is a slightly narrower than Deb's research area. I have no expertise in competition law, so my comments will focus on the first three young corporate law scholars' papers. Although I find that the fourth and the fifth presentations are very interesting, talking about competition law. But I think I would be more qualified to comment on the previous three presentations. The first comment is for Bell's voluntary disclosure paper. It is a timely paper given the major source of law, PRC securities law, had just been revised in 2019, which provide Bell a fresh material to research upon. Although the legislature has long held it aim of enhancing investor protection and continuous disclosure mechanism during the revising and amending process, it is hard to find a substantive adjustments on the materiality criteria within continuous disclosure provision. She also mentioned in her paper. The price sensitivity has long been employed as the standard, regardless of its completeness, which I think jeopardizes investors' protection. BEL focuses on the new voluntary disclosure of the new securities law, considering the foreseeable confusions and conflicts on the newly added voluntary disclosure standard. The empirical data and analysis in her paper matches out some possible problems. She also suggested juridical interpretation from Supreme People's Court might be helpful, and in the long run, incorporating the investor decision standard into mandatory continuous disclosure provision is meaningful. I believe there might be a couple of issues worth further pondering for BEL to improve the quality of our paper. The first one, I think, is whether the abstractness in Chinese national level securities legislation is an intentional legislation approach or an unattended outcome due to asymmetric information. This is critical for any scholars want to do Chinese law research, because in Chinese commercial law, usually you can find the legislation style is in a very abstract way. Whether the legislature in their mind, they are considering the asymmetric economy development in China. That's why they want to leave some leeway for enforcement department to further explain, or they just don't know about that. They just want to offer a broad brushed law so that can provide administrative agencies more power in regulating the market. This needs to be further explored to justify your suggestion. Then the second question or comments is how to make your suggestion more practical in civil law context is also a direction you can head in towards. Usually a juridical legal explanation in China can solve very limited problem, because if you look into the past juridical legal explanation in corporate law, usually they also relatively abstract and broad-brushed as well. Juridical, like Supreme Court of China, usually they want to provide quite a lot of freedom for market supervisory agencies to enforce law. Do you have some more practical further steps to make your suggestion workable in China? One of the interesting suggestions I read from other scholars' paper is since the juridical legal explanation and the legislation are very abstract, perhaps we can consider professional courts like the corporate courts, just like the Delaware court in China, so that the judge's professionality can reinforce, can make up some shortfall due to the abstractiveness of law. So those are two comments I offer to BEL's paper. And the second group of comments or questions for Rosa. Rosa is presenting a very interesting topic, which is relevant to corporate governance under the threat of pandemic. That reminds me last time's Chris Chen from Singapore Management University's presentation. He roughly talking about a very similar topic, which is very, very interesting. I think some of his point of view perhaps will be helpful for Rosa to improve her research paper's quality. The first one is from, I think it's very much from previous Chris comments, that is how to supervise the board of directors or the management is the bigger problem at the moment. I think the technology and social distancing make supervision harder. For instance, when deciding a director's duty of care, there are less evidences in terms of a degree of diligence you can find, especially when every directors or management members, they sit behind the screen and you have no idea what they are doing. Then the second comment is, I think Rosa mentioned a little bit in her paper, but I think this should be the core of the paper, research on corporate governance under the pandemic. That is that the predicted change in the corporate law are very much based on people's lifestyle change during the COVID-19. What I think might be interesting is how many unusual ways of living will continue after, if we have enough luck, we conquer the pandemic. Say we have a very valid vaccine. How many aspects of our lives have been entirely changed by the pandemic, permanently changed by the pandemic? If we cannot define that, we do not know how to address those issues incurred under the pandemic. How sure we know about this? Those questions must be answered before we raise any legal suggestions for legal reactions. This is the comments / questions for Rosa. Lastly, let's take a look at the Schwartz presentation. She discussed a very important topic under the pandemic, nursing home regulation for Chinese law, from a Chinese law perspective, also known as NPRI, nonprofit retirement institution in China. In the Chinese nonprofit nursing homes, she believes corporate governance should be a stakeholder approach to include the multiple interests of clients, regulators, and donors. It is highly important, I believe, for nowadays Chinese nonprofit business organization legislation. The existing law is surprisingly empty, I agree, and it needs further work to at least building up a basic framework. I think that's the first priority for Chinese legislature. Both internal and external accountability are discussed for non-profit organizations. The paper proposes that the current system of accountability can be improved by reforming existing laws and learning from, this is a key point as she raised, from Chinese for-profit companies' legal practices. I still want to suggest two things, two comments for her further consideration. The first one is it should be great to explore further the differences between for-profit and non-profit firms from the regulation perspective. If you want to learn from business organization corporate governance rules, to what extent should we learn? Anything should we learn? Should we learn how much we should change the legislation of the business organizations? This could be a key point. You need to differentiate the difference between for-profit and non-profit firms regulation. Then the second is shareholders are major private enforcement group in corporate law. Then the very logical question following is, in order to launch an NPRI or nursing home legal system, who should be the one to enforce the law for NPRI privately? For-profit could be shareholder, but how about non-profit firms? If you don't think you don't need a private enforcement, then you need to justify barely public enforcement is sufficient for NPRIs in China. This could be a missing piece in your thesis to justify your suggestion. I think I used quite a lot of time. I used almost 10 minutes. We need to enter into the next stage, which is Q&A stage. I saw our presenters are very enthusiastic. They've already asked questions. Yes, so I still prefer to give you guys like 10 seconds. If you feel your question is interesting, somebody else's question is interesting, you can press like on their question in the published column. I will choose the question with the highest like to ask our speakers first. Yeah, just take a look. Oh, it's already there are quite a lot of questions right now. Oh wow. I've already found 2 like question. Oh, 3 likes. That's quick. So let me take Emma Armson's or Emma's questions first. It's for Belle. Okay. So hello, Belle. Thank you for your very interesting presentation. I also had a question relating to the operation of the voluntary disclosure regime compared to the compulsory disclosure regime, which I understood applies a price-sensitive standard. Do you have any comments on the interaction between the voluntary and the compulsory disclosure regime? For example, I was wondering whether it is clear to the investors when the company considers that the information is price sensitive. If not, is there the potential for investors to be swamped with information that may or may not be price sensitive? Yeah, please, Beth.
Thanks, Emma. Thanks for your question. Actually, the introduction of the voluntary disclosure into the whole disclosure regime have very minor influences on the disclosing process. The problem lies in when investors seek civil compensations on the non-compliant continued disclosure, and when judges are dealing with civil compensation cases. Like the investor decision standard would be more broader than the price-sensitive one. And the provisions in the securities law of PRC has listed up to 21 circumstances that constitute the material matters. For those circumstances that outside of the list, that in that part, the judges need to use their discretion to decide whether this information belongs to material ones and need to disclosure under the mandatory continued disclosure rules. And previously, the judges would seek their discretion and judge according to their investor decision standard. Like, irrespective of that, these circumstances are not price-sensitive ones. They are still investor decision-sensitive ones. So judges would like judge this information as material ones and give compensation to investors, but the introduction of the voluntary one specifically distinguishes these two standards. Like if the information is not included in the list, the judges cannot use their discretion like this is not price sensitive, this is investor decision sensitive, it still belongs to material information, but currently the judges have to cannot say, well, this is the investor decision, you still have to disclose. Because this the company would say, well, this belongs to voluntary disclosure obligations. I don't have to disclose it monetarily. And this would much narrow the scope of the possibilities that investors can seek civil remedies on the non-disclosure of certain circumstances. Hope that can explain your queries.
Thanks, Belle. Okay, let me see the second. Oh, Emma. Not sure. 1 like. Oh, I found 2 likes. Oh, it's for Rosa. Hi, Rosa, from Belle. Thanks for your presentation. Very interesting topic. I have 2 brief questions. How technological capacities and availability of technologies which become very relevant as the result of the pandemic can influence corporate governance practice? First question. The second one is, what are the changes that might occur with the traditional role of the corporate directors? So Rosa, please.
Thank you very much for these great questions. With respect to the influence of technologies, I actually attended the seminar that Charlie mentioned with the Professor Chris from SMU speaking on the future of technologies and their role in corporate governance. And he also mentioned the virtual meetings and how they're going to affect the duties of directors and monitoring problem when how shareholder can be sure that the managers and directors, they comply with their duties. But my point that I'm trying to make in my paper, I think is a little bit different because I talk about, so I believe that technology will catch up. It's not about the fact that we don't have technologies. I think they will be quite available. Now we're using technologies quite successfully, except for me, I failed with my mic before. But anyway, I think technology will be available and we will continue using them quite successfully. But they will probably remain quite disproportionately distributed among countries and regions and even companies. And because there will be disproportional distribution of these technologies and the access to these technologies and tools, and also because some companies will probably prefer to, because of the size and number of shareholders, or because their businesses, they will apply less technologies, or because they will not have sufficient financial resources to get these technologies. I think this distribution will affect the way how companies will govern their business. And it means that if this gap between corporate governance approaches among different companies and different jurisdictions will increase, that requires us to have a second look on how we see corporate governance, what tools of monitoring and oversight we use, and how to make it available and successful in the current circumstances. So this is the answer to the first question. And with respect to the second question, as I mentioned, and we all know that the firm is a very abstract entity. It's considered as a nexus of contracts. And the question is whose interest this the company or the firm represent, either it's shareholders, employees, or stakeholders, creditors, community, and so on and so forth. In my view, the essence and nature of the duties of fiduciary duties of directors might not change, but the application of these duties can change because of the focus on the different kind of interest. I think the current fiduciary duties were mainly designed to serve shareholders, sometimes because shareholders are considered to be equal to a company as an entity or a company per se. But what constitutes the company, which interest company represent, will affect, I guess, the application of the duties, as I mentioned. This is, my brief answer to your two questions. Thank you very much, and I hope it's clear enough.
Thank you very much, Rosa. It's very, very good answer. I trust that Matthew, you would like to address the Deb's question first, right?
Yes. Yeah. Thank you, Deb, for your comments and questions. I found that they are very interesting questions and very helpful to me to further polish up my research. And to your first question, I think, yes, I think the approach to abandoning the competitive relationship will better protect trade secrets in China. And as I mentioned, the most common happened misappropriations of trade secrets, well, in reality, is that the employees often misappropriate the trade secrets and join another competitor. So by taking an approach to the intellectual property protection, it can be better protect companies from being misappropriated from the employees. And the second question, I think it's really hard to say when the new standalone trade secrets law will be enacted, because, as you know, it will be a very complex legislation process in China for the National People's Congress to make the law. But I can share a trend and information regarding the standalone legislation. That is the Supreme Court, the Supreme People's Court, just in this year, in April, has enacted a standalone judicial interpretations on trade secrets protection, and it is now for the public to comment, and hopefully it will be published later this year. And the trade secret part was formally enacted in the unfair competition interpretation, and we could see a trend that the Supreme Court has takes the approach to enact a standalone judicial protections. And the third question is about the interactions between antitrust law and the trade secrets law. I think there may be some overlapping fields between trade secrets law and antitrust, and from a broader sense of view between the intellectual property and antitrust. I think the abuse of trade secrets should be analyzed in the antitrust framework, such as the abuse of market dominance, but the antitrust law, in China we call it anti-monopoly law, cannot address every concerns. I'll take an example. For example, a refusal to license trade secrets may constitute the abuse of market dominance under the anti-monopoly law, and in the EU or in the United States, the liability to of breaching the antitrust law. Sometimes the competition agency will compulsory license the trade secrets, or in other cases compulsory license the patents to its competitors. But such kind of liability is not enacted in China's anti-monopoly law, and it is usually stipulated in the standalone intellectual property law, like patent law and like the trade secrets law. I hope it will be enacted in the future. I hope my answers could solve your problem. Thank you.
Okay, great. Thank you, Matthew. So I saw a question with a lot of likes. I'm gonna ask Ashur first, but after that, I'm gonna offer Martin some time to address the comments from Deb. So Martin, you might be prepared. So the question for sure right now is from Emma as well. Said, hello, sure, I enjoyed your interesting presentation on such an important topic in current times. I had a question. Can you elaborate on the way in which stakeholders can be involved in decision making, and what mechanism would require to make this, would be required to make this feasible to allow the bodies to be governed effectively?
Okay. Thank you, Emma. Thank you for your question, and thank you, Charlie. And I also think that there's someone said the question about the new Chinese civil law. I would combine these two questions because the new Chinese civil law has made some changes on the nonprofit organizations, and it will influence the corporate governance of the nonprofit nursing homes. As I just said in my presentation, the main stakeholders involved in the nonprofit nursing homes are the regulators, the clients, and the donors. The donors also the founders sometimes. And these are key stakeholders, and they can have the ways to, and they have some measures to participate in the decision-making process. For example, there are four main measures they can participate in. The first is the stakeholders can elect the direct holders. That's the first process. The directors, the stakeholder, they can elect the directors and the supervisors. So when they elect the people in the two-tier board, that's the first way they can participate in the corporate governance. And then the stakeholders may attend the board meetings, especially the board of directors meetings. In this way, they can get the information of corporate governance and know some information of the changing of the organization. And the last one is I can think about is a enforcement measure, as as Charlie just commented that there are public enforcement and the private enforcement measures. But in China now, the regulator, they have the public enforcement measures, but for the private enforcement measure, they are empty, especially for the clients and the donors. Yes. So that's my answer. Yeah, thank you.
Thanks, Shore. Thank you very much. So the next is Martin. Martin, please address to respond to Deb's comments a little bit. Thank you.
Okay. So first of all, thank you very much, Professor Haley, for her insightful comments. And I just want to give a few quick response. So first of all, about the title of the paper, I choose the word settlement because under the free track system, we also have the commitment system. So I feel like if I use the word commitment in the title, it will mislead the reader that I'm referring to a specific, like the Section 60 commitment system. So, but I understand that using the word settlement also create other problems. So that's something I need to think about. And the second point is about you mentioned that in my paper it sounds like that a suspected party will always enjoy commitments from the commission. I agree that that is not the case because, as you said, the law enforcement agencies, they will review the case very carefully and decide what case to settle. But I just what I want to state in the paper is that given the possibility of like no financial punishment itself is too lenient. Like even though the possibility may be very low, but given that possibility itself is not ideal, and it may also give a false hope to companies and make them feel that, oh, if I violate the law, there may be a chance that I may get a settlement and then I can walk away freely. So I think that's not ideal. And the third point I want to make, I totally agree with you about the SMEs concerns in during the legislative process. For example, during the legislative process, many of the SME concerned that they may unwittingly avow the law, or maybe the law will be abused by the large companies against them. So I totally agree with you that the SMEs and the things happening around that around the deliberation process of the law have led to a lenient system in Hong Kong overall. And the last point I want to make is about the admission of guilt. I need to do more research on this, but I feel like that in some systems, for example, the EUY, they always require admission of guilt because the decision to make a settlement already constitute a prohibition decision. It means that like if in the EU, my understanding is that if the suspected party settle with the antitrust authority, then they are already subject to fine. So if they are not required to admit to their guilt, it will be very bizarre to see that they are fined, but at the same time they don't admit to the guilt. But in Hong Kong, we don't have this case because the Competition Commission only prosecute and investigate the case, and the case is decided by the tribunal. So in Hong Kong system, I think it's still possible to see that like there's admission of guilt rather without a prohibition decision. So that's just some of my quick response, but I certainly need to do more research and follow up on the comments. And thank you again, Professor Haley.
Thank you very much, Martin. Great. Everyone, time flies. I believe you all enjoyed the session very much, just as I did. And time is too short for us to discuss all the questions from the audiences. I still see a lot of questions left. One of the online conference feature that I feel not comparable to an in-person conference is that we do not have a chance to chat about our academic interests and concerns after the conference. Further, all 5 topics being discussed are vital for economical operation under the pandemic. They also will invoke more echoes in academia, I believe. I also believe with so many promising young scholars, we finally will defeat the virus and minimize the economic impact of the pandemic, and the corporate and competition law, of course, will play an irreplaceable role in the fight. But Last but not the least, I need to thank CIBEL for the excellent chance for us to discuss the corporate and competition law. Also, I owe all speakers a big thanks for the great presentations. Without our excellent, lovely CIBEL staffs, Fiona and Jane, the panel will not be organized successfully. I'm sincerely appreciative to what they've done for the session. More importantly, thanks to you all for participating in today's session. Have a great day and goodbye for now. Thank you.
Bye.